Amid all these police cuts and the imminent collapse of law and order, the one thing I don't wonder is, do we have enough police officers to protect the LGBT community from having their feelings hurt? But that's because I'm not a left-wing progressive, patrolling the playground social media, virtue signalling to other progressives about how right on I am with gender issues. In fact, I measured how much I give a toss about LGBT hurt feelings, and it came out as this much. I put a P in there just to give it some scale. Unlike this guy. Oh, sorry, check your pronouns, because it might not be a guy at all. Hang on, let me just get my dictionary of politically correct gender pronouns. I meant they, he, her, she. Oh, God, whatever. I'll just call him Plod, because it's the Met Police who own this Twitter account and employ this useful idiot to sit in HQ ivory towers, wagging a virtual finger at anyone who dares speak out of turn about one of the police's most favoured victims. The lesbian, gay, bisexual, transsexual community. That mafioso of alternative sexual lifestylers who think that Article 10 rights of freedom of expression only apply if what you're expressing is something you've just taken offence to. And they don't just take offence, they go virtually begging for it. Trolling forums, Twitter feeds, Facebook postings and blogs for something, anything that will elevate their victim status and allow them to scream hate crime at anyone who doesn't abide by their worldview. You only have to scroll through the LGBT network Twitter timeline to see it serves no other purpose than to promote the ideology of one minority, often at the expense of the majority. Because up until quite recently, it was being routinely used to persecute and bully those who dared criticise anything other than white heterosexual lifestyles. Most people on the receiving end of this McCarthyistic vitriol either deleted their postings or closed their accounts. In other words, the LGBT account was doing what it intended, censoring free speech on the internet by implying threat of the force of law if the tweet didn't conform to the state narrative. On the 12th of August 2016, Mr. X, as I shall refer to him, tweeted the following remark about the British team at the Summer Olympics to the Daily Mail. Is the whole of Team GB gay and or ethnic? The next day, the Met LGBT retweeted it with the following comment.
Another reason for our network. An undercurrent of homophobia, racism and just general nastiness right here.
Mr. X saw the tweet and was incredulous, so he asked if it was a genuine Metropolitan Police account. They responded with,
Yes, and feel free to write to Scotland Yard with your request for his staff details. We're a staff support association within Met Police UK, but we also focus on hate crime and responding to trollers.
At this point, another Twitter user chimed in that the Met only seemed interested in targeting heterosexuals with this virtual rock throwing, to which they replied,
We're very welcoming of straight people. My mum is straight, she loves gay people. Hashtag love wins, hashtag equality, hashtag join us.
That was soon followed by this bizarrely sinister tweet.
Delighted you've taken an interest in us. We'll take an interest too. Open source is a goldmine. Give my love to Caroline.
Caroline is the name of Mr. X's wife. How did the Met tweeter know that Mr. X's wife was called Caroline, given that it had never been mentioned nor had she been the subject of the conversation? Either way, Mr. X took it as a veiled threat that he and his family were being monitored, as well as being accused of committing a potential hate crime. Soon after this, Mr. X became the focus of attack by other virtue signalling progressives who danced to the tune of the Met LGBT drum, and they began sending him hateful messages. Believing both he and his family were at risk, he deleted his earlier tweets. He then lodged a complaint with the Met Police, who, true to style, excused the police employee of all wrongdoing and instead heaped all the blame on the complainant. And they took a long time doing it. It wasn't until late 2017 when Mr. X got in contact with me via my Get Help service and asked if there was anything else he could do. I recommended he sue the Met Police for breach of data protection and harassment. He could also add his wife to the claim because it was clear from the LGBT network's remark that they'd used police systems to check up on her, even if that check was nothing more than searching Mr. X's own Twitter feed and his list of followers to identify his wife's name. Now, you might ask, how could that possibly be a breach of data protection if the information the police retrieved was already in the public domain? Well, that's because the Data Protection Act doesn't have a public domain exemption. But what it does have is a strict list of protection principles that all authorities must abide by when processing data. And yes, just scrolling through somebody's Twitter or Facebook account, if they're a local authority, is processing data, something that no public authority has a right to do without accountability. If these agencies have been performing a search for information on you via any system, internal or external, you have a right to know under Section 7 of the Data Protection Act. And where the processing of that data is unreasonable or excessive, as it was in this case, you have a further right under Section 13 of the Act to sue for damages. The established authority and awards for data protection breaches of this type is Halliday v Creation Consumer Finance, which awarded the claimant £750. So, in line with this precedent, and for the data protection breaches alone, the claim stood at £1,500. So, what about the harassment element? Well, Section 7 of the Protection from Harassment Act interprets harassment as a course of conduct on at least 2 occasions that causes alarm and distress. The Met LGBT had posted more than one harassing remark, despite Mr. X's objections, and none of the remarks served any policing purpose. They were designed wholly to intimidate and nothing else. Section 3 of the Act provides a civil remedy for claims of harassment, whereby you can pursue damages via civil proceedings. As Mr. X's wife had only been the subject of one remark, she had no claim for harassment. So again, in line with precedent, I set the harassment damages at £1,300 and then calculated aggravated damages at £1,200. This brought the final total to £4,000. On receiving the letter of claim, the Met lawyers made no attempt to deny the data protection element, but objected to the harassment claim. Rather than face the awful prospect of losing in court and being publicly humiliated, they settled on an offer of $2,750. Not bad for someone who isn't a solicitor and doesn't have a law degree. What I do have though is 6 years worth of legal study, practice, many thousands of people I've helped through the website, and dozens of successful lawsuits I've brought against the police, none of which have ever resulted in me stepping foot in court. So, what all this proves is that public authorities need to be very careful about the way they use social media, especially when they're using it as a means of naming and shaming members of the public or performing unnecessary searches of their profiles. It also demonstrates that when it comes to using social media to spread intolerance, spite and threats, nobody does it better than the police service.